Ever had the distinct pleasure of hosting or moderating a panel after lunch. You don't get the usual response from the crowd at that time or the audience. So very good afternoon again. I'm sure we've had an interesting time right from this conference started in the morning. From the first session dealing with the outmoded Labor Act and sharing perspective on what can be done, to the second session on the Great Japa with Ucheibe, the table shaker, giving us rich perspective as to what and why this will continue. Now, taking away from all that, this session is situating the world of work, even in this terrain, within international best practices, global best practices. And so, thankfully, I mean, it's a session that, it's a conversation around international best practices, but I think a lot of what we'll be discussing would provide or attempt to answer what the concerns are with the other two sessions that we've had. Because we'll be discussing how, for instance, adjudication of disputes in this climb can be seen or is being done from the context of what's happening in other terrain, I mean, other climes, within the context of international best practices. And Nigeria being a member of the global community and the International Labour Organization, it is rather very important that what we do here is seen in the context of what obtains within international best practices. And to drive the conversation, let me draw us back to what I recall that the president of the Industrial Court said as part of his opening remarks at the 2022-23 New Legal Year celebration, in giving an historical perspective as to how or why the Industrial Court here can try disputes submitted before the courts and apply international best practices when sitting on such matters. And in particular, my Lord, the President had made reference to the Section 7 of the Establishment Act, which allows international best practices to be taken into consideration and ultimately, I mean, 254 of the Constitution has been taken from or been borrowed from Section 10 of the Industrial Relations Act of Trinidad and Tobago. And that, I mean, that was taken from it that in the context that in the adjudication of dispute, the courts can apply international best practices. And that international best practices will be seen as a question of fact. So, I mean, it's based on more like case-by-case basis to be able to bring the context of how would it be addressed? How is this being done globally? And that question of facts aspect was introduced so as to ensure that matters like that, once decided, you don't go on a frolic of an appeal. And you can only go on appeal with leave of the appellate court. And quite a number of things and how we are where we are today. Now, let's bring it home. This panel or this session will be having a conversation around international best practices from the perspective of the courts, from the perspective of the practitioner, and from the perspective of perhaps a sector that is expected to be more involved. I mean, to draw from what Ucheibe said, we can't be making any law about labor. We can't be having conversation about labor without getting HR involved. And thankfully, I think we have the CIPM president to also have a bite around some of the issues around international best practice. Yeah. So it's not my session. So I'll go straight to my Lord. I'll start with my Lord. The first question, international best practices and the national industrial courts. It says that by the virtue of the provisions of 254C 1F of the Constitution, the National Industrial Court is conferred with jurisdiction to adjudicate on dispute relating to or connected with unfair labor practices or international best practices in the Nigerian labor industry. Now, the categorical question is, how well does the NICN or the industrial court try to situate the applicability of international best practices within our local circumstances? Earlier on, they were talking about the Labor Act being 74, 1974 Act. And then the practitioner comes before the courts, hoping to say this is what section 10 section of the Industrial Code of Labor Act says. And I mean, generally within our local circumstances, my lord, how well does the court take that into consideration? Thank you so much, my lord.
Thank you. When we're talking about, when we're talking about international best practices, we cannot talk about international best practices without, first of all, understanding the intendment of the provisions, both in the Constitution and the Establishment Act of the National Industrial Court. The purpose for the best practices provision, both constitutionally and in the statutes, is to bring the labor law, the 1974 labor law. And I would just say this as a side remark. The amendments, proposed amendments to the Labor Act have been in the National Assembly for years. That's part of the problem. And nothing has been done. Now, bring the Nigerian labor law in alignment with international law. And I put international law in quotes and say international best practices. And this is not strange because if you look at the Constitution, Section 19 of the Constitution, the foreign policy objectives of Nigeria, one of it is to respect international law. Particularly those laws, those treaties, those conventions, protocols, recommendations that Nigeria has signed, Nigeria has ratified. So there's no running away from international best practices and its application in labor. Nigeria is part of the global community. The global community cannot be in the 21st century. In 2022, we're going to 2023. And then the labor law will be in 1974. That is the intendment of international best practices. And when we have disputes that come to court, the facts of the dispute determine the international best practice that is going to be applicable. So the facts of the dispute forms the base for the application of international best practices. And what has the National Industrial Court done with international best practices? The application of international best practices in dispute resolution has been used to strike down issues of unfair labor practices. So, for example, we were talking about, is it maternity leave? Just the Yes. In fact, no, recently we're talking about, the previous speaker was talking about maternity leave, that the maternity leave provision in the Labor Act is 1974. And so much has happened. At that time, there was no consideration with respect to stillbirths, with respect to premature deliveries, with respect to women who become very ill, even during pregnancy and after pregnancy. So all those issues were not taken into consideration. Now such matters come before the court. The court can sit down, look at it, and decide whether or not to apply international best practices. You know, Section 7 of the Act talks about the fact that the courts in resolving disputes should have due regard to international best practices. And international best practices is a question of facts. Now, when you're talking about international best practices being a question of facts, we know that the conventions that Nigeria has ratified, the International Labour Organization conventions ratified by Nigeria, the protocols, the treaties, the recommendations, all those are evidence of international best practices. So where the country has ratified a convention, say for example, Convention 187 and Convention 190, which Nigeria has just ratified. I think it was November 7. The Minister of Labor went to Geneva to do all of that. So conventions like that have become part of our labor law. Such conventions, you do not need to plead in your pleadings because it's part of our law. But those conventions that are not ratified, and when I'm talking about ratification, I'm talking about labor. Because of course, somebody can talk about, oh, but those conventions have to be domesticated. Not when it has to do with labor issues. Conventions, treaties, and protocols that deal with labor issues by the provisions of Section 254C, 1, H, F, and Section 2 do not need domestication once they are ratified by Nigeria. So once they are ratified by Nigeria, they are already evidence of international best practice, which we can go on to apply. But where it is not ratified, for example, the Convention on Termination of Employment, where it is not ratified and you want the court to apply it, then you have to plead that convention. It must be in your pleadings because the law says it is a question of facts. And that convention is yet to be ratified. But it is an evidence of international best practice. So you have to plead it in your statement of facts and then prove it. I don't know whether I can continue or whether I should stop for now. I should stop for now. Thank you.
Excellent. A round of applause. Wow. My Lord has given indeed a very rich broad perspective to the question, which is essentially focused on what the court takes into consideration. And then my Lord has gone to not just give us what the court takes into consideration, and also offered useful hints as to how to even bring evidence of this international best practice or practices before the courts. That leads me to my second question, which I'll be posing to my Lord Honorable Justice Anowe. And it goes thus, my Lord. The provision of Section 254, still the same provision of the Constitution and Section 7 of the National Industrial Code Act, have been celebrated for the additional powers they have granted the National Industrial Court to apply international best practices and international labor standards in determining disputes between employers and employees. So we started in the morning with the Labor Act, but thankfully we're now discussing that the Establishment Act and the third alteration now fortify the courts to look beyond the local Labor Act. Now, the question is, are the courts circumscribed by other consideration? Some of which I take that my Lord and Justice Obaseki Sage has addressed, but in particular, this part of the question is, are there steps that employers must take to benefit from the provisions of the law? And the reason for that is not far-fetched from the common take that what is international best practice is often mirrored from the misconduct of the employer, as opposed to hardly does the inaction of the employee comes before the court and the question of international best practices or best practices being discussed. That's okay. Are there things that the employer must do or areas that the employer must do also begin to benefit from international best practices? Thank you, my Lord.
Thank you very much. So, now, a lot of what my Lord Justice Obaseki Osagaye has discussed relates to this question. So I'll just keep going through the issues relating to Section 7 of the National Industrial Court Act, which specifically refers to the use of international best practice in labor and industrial relations, and which ought to be a question of fact. Now, once a convention or treaty has been ratified by Nigeria, it becomes applicable, and it takes away the need for domestication as prescribed by Section 12 of the Constitution. So it kind of, if you look at the wordings of Section 254C 1 and 2, it starts with the phrase notwithstanding any other provision in the Constitution. To me, I take that to mean that I can do away with Section 12. And then I do not need domestication to enable me apply an international labor standard, basically. And of course, I also have to look at the facts. Now, the other part of the question is whether the court's powers are circumscribed by other considerations. And I would say that the ratification essentially gives the courts the right to use those standards in adjudication. And I do not think the court's powers are circumscribed in any way. And then the steps employers must take to benefit from the provision of the law. I listened to the earlier speaker, Mrs. Mojeku, the HR expert, and I'll toe her line and say that HR has a huge role to play in what employers must do to enable them to benefit from the provisions of the law. The HR would naturally guide the employers to know what they must do to comply with those standards. And of course, the HR will not work in isolation. If the standards are complied with, the conventions are complied with, of course, there will be they would naturally benefit from the provisions of the law. There won't be any need for any back and forth on the issue. Basically, the only snag that will give a strict application to the need for a stricter application of facts is the fact that a convention was not ratified. So for as long as it is ratified, we have a smooth sailing ordinarily. In a few cases, just like my Lord Obaseki has pointed out, like Convention 158, in cases of termination without reason, we generally hold that the reason must be justified and established. And that is just, basically, even though Convention 158 was not ratified, it still forms part of the international labor standards already established by the ILO. Well, I don't know if that would do for now.
Yes, my Lord. Thank you so much, my Lord. Please, a round of applause for my Lord. For the great insight shared and in the answers given to the question posed. All right. I take it I will listen to the courts. My Lord, this is the only opportunity I get to pose questions to my Lord without being cited for content. So, my Lord, thanks so much, my Lord, for the privilege. And I'll take it away, and now let me take it to Dr. Taro SAN to give us a practitioner's perspective. First with, the conversation that we're having around international best practices. What are your preliminary thoughts, sir? International best practices. There's a major question I'll bring a month later to you, sir, around compensatory damages. But for now, what are your preliminary thoughts around the international best practices? And sir, Mr. Moji, the same question I'll be asking for preliminary thoughts, sir. Okay, sir.
I don't think let me use your own analysis. Thank you, my lords. My lords, they have spoken very eloquently, very eloquent expose of what constitute international best practices. I want to say without any equivocation that the best that has happened to the employment market law in Nigeria is the use of international practices in adjudication. There in this case I did is I think it has changed the narrative in the jurisprudence of labor law. And I regard the provisions of section 7.6, 13, 14, 15, 16, and 19 of the National Industrial Court Act, and the previous section 254C, F, and H of the 1999 Constitution as amended, the legal and constitutional anatomy of the jurisprudence of the jurisdiction of the National Industrial Court. In Sahara Energy Resources Limited and Oyebola, which was edition of the Court of Appeal, were delivered 2 years ago, says that one, you cannot just go to court and say, oh, you want the court to use international best practices. But your claim must be predicated on facts. Not only that, it must be a claim that you are asking the court, because what is not claimed by you, or a relief that is not claimed by you, you cannot, the court cannot give it to you. The court is not a Father Christmas. Having regard to the decisions in Green and Green, there was a decision, the case of Nasarawa Specialist Hospital Management Board and Mohammed. He won at the trial court. The court awarded 2 years' salary. But on appeal, they said, no, you didn't claim it. How can the court award what is not claimed? But in my own case, I claimed a lot of reliefs. I even claimed general damages. And what I want to sell to our colleagues here today is that there is nothing wrong in claiming many reliefs. Just claim it. Yes. claim any relief, the court will decide or would want to give to you. But if you don't claim at all, the court will not give you. It's like Nemo that, quote not, habit. What you don't have, you don't give. If you don't claim, nobody's going to give it to you. And I raised a point in that matter. And we lawyers, we are familiar with ubi jus, ibi, remedium. When there is a wrong, there must be a remedy. And that is encapsulated. I would say that principle of law is in a way entrenched in international best practices. I raised it. I said a wrong has been committed by the employer. And since a wrong has been committed by the employer, there must be a remedy. And the court agreed with me. And that is provided even under the National Industrial Court Act, under Section 13 or 14, that the court has the jurisdiction to grant any remedy. And so that is the best that has happened to the labor force. So I think it's a very good, a good enactment, because a lot of employers, what they do to employees, is of becoming of some of these employers. So I think, and the National Industrial Court has been doing that over time. Like, for instance, the case of Bello and EcoBank, when they use the termination of employment convention of that is number 158, which my lords have referred to herein. That decision was given sometimes in 2018. And my Lord Joseph Aloe stated that, well, the two of them even stated it. Even though you don't have, once you plead it, even though it's not enacted or it's not ratified by the government, by the federal government, then it can be used. Section 254 actually encapsulates everything that has to do with international best practices. Although international best practice is not defined in the Constitution, but we all know what it means. Something that has to good standard, quality. If you see something that is good, if you see any enactment that is good, you will know that this is a good enactment. And if you see any ethos and pathos relating and a connection with what we make the labor force to be robust, or any labor law, of course, the court can make use of it. And that is why there is what I can describe as a paradigm shift from the common law principle of master-servant to what is now known as international best practices. I think I'm done for now.
Well, so I'll just stay here. Again, a round of applause for the very profound insight shared by Dr. Otaru. Now, I'll need to give it to the CIPM president. It's the same question. Do you agree, sir? Or what are your thoughts on the international best practices, perhaps seen from the perspective of the human resources sector?
Folabi, I know that I'm going to come from the human resource sector. You are not going to hear sections, this from me, and I'm not going to put it to you. So let us get straight to the point. The human resource profession believes so much in global best practice. In fact, without it, we are nowhere. We are not, we are not an island on our own at all. We used to say that the world is a global village. No, in HR, we now say the world is a global capsule. No, capsule is as small as a capsule. Nobody winks in the dark. We are now boundaryless. These are HR terminologies to show that we benchmark with the best in the world. The initial thing from the HR to the National Industrial Court, trying to see it as a court that is tilted towards the employees is the fact that some of us, Falabi will bear me witness, the last session where you were there and my other brother, Adwale Jones, were there. You people turned it into a court, and I became the chief judge. So, is the fact that some of these, not knowing, some of us still don't know that once Nigeria is a signatory to these conventions, statutes, and so on, the court can begin to apply that. And because even 2-3 days ago on our platform, somebody is still saying that even the paternity, the 14-day paternity, we have to be encoded somewhere in our law before it could be used. And I said, since Nigeria is a signatory to, because I don't do much public chats, whatever you say is taken as the president of CIPM has spoken. So I go to the individual privately and said, I think this one has come to stay. Therefore, our take is that international best practices or global best practices is what we cannot afford not to adopt. We do it every day, not only in the area of law, in the way we manage our people. In employee well-being, we adopt international best practices. In our headhunts, in our talent search, we adopt these things because they do us good. And if we could adopt the good, in quotes, side of those, global best practices, those ones that are not too good also, we should be able to. Now, I can tell you that already practitioners have learned, because the fear of NICN is the beginning of wisdom. So those cases that have already been decided have become resources for us. We read those cases like no man's business, and we circulate. That's why CIPM, we've gone the education and the advocacy way to embrace these international best practices. So if you want to fire now, it's no longer enough to say service is no longer required. We are there. That is why we go through thorough process. It is documented, and we are no longer afraid to put it there that this is the reason you are going.
Fantastic, sir.
And the person who is also exiting now, everybody is respecting him or herself. I will pause here because and to probably
very eloquently said.
Thank you.
Applause. A round of applause. Well, you started by saying that you were not going to quote laws, but you ended up quoting the cases for us, almost like taking the job away from us lawyers. Thank you very much, sir. Very eloquently said. And it's good to know that we are all relating with international best practices. I mean, that appears to be response given to on first set of questions. So it takes me back to one important area where the local laws are insufficient or we don't prevent and travel abroad. Now, the starting point many a times for practitioners in that area, in this area, is to seek opinion. We've already identified a lacuna. You seek an opinion from international labor organization conventions. My Lord Honorable Justice Obasi, this question is for my Lord. And in some instances, some of those conventions, they refer you back, or they seem to defer to the national law. And I'll give an example on redundancy. The letters of the law, our local law on redundancy, is so bare, little said. So you try perhaps consult the ILO Convention on Redundancy. Expect compliance. Okay, I think it's better here. Expect a compliance with national law and practice for redundancy procedure. So that's all it says, that if you are to declare redundancy, comply with your local law. Now, the only national law on redundancy, generally speaking, is the Labor Act. Meanwhile, Section 91 restricts application to clerical staff. We discussed that. How then do employers comply with international standards in those areas where none exist? I mean, international standard that is referring us back to the local laws. And then will employees not be bound by the provisions of the Labour Act, be left simply to the provisions of contracts of employment? Thank you very much.
No, it's not working.
Thank you. When all the ILO conventions, when you look at the articles, you look at the recommendations. The recommendations by the ILO Committee of Experts. You also look at the fact that there's a committee on standards in the ILO. The ILO doesn't operate in isolation. It respects the sovereignty of the individual states. So when it's talking about national laws, it expects that all member states that have signed up to these conventions will go back and enact laws that are in line with international best practices. So when we talk about national laws and redundancy, our Labour Act, yes, may be very old, but there is a provision on redundancy in Section 20. And that provision, as old as it is, still meets up with best practices. You will find that in most of the employee or employee handbooks or the contract of employment where there's provision for redundancy, you will find that the employers have just lifted the provisions of Section 20 in the Labour Act. So we cannot say that we don't have any national law on redundancy, because the provision of the Labour Act gives the employer the procedure it is to follow when it declares a redundancy. And when it declares a redundancy, it must inform the trade union or employee association or the employees, if there are no trade unions in that organization, of the redundancy and the extent of it. The provision also gives the employer the obligation to negotiate redundancy payments. In some of the contracts of employment or employee handbooks, you will see they have stated the redundancy payments the way it is going to be. But where the organization doesn't have that, the employer and the employee associations or trade unions must negotiate. And that is what is also known as social dialogue in the ILO. And what is the purpose of all of this? It is to ensure that employee rights are protected. Because the main focus of the ILO is to ensure what it calls a decent work agenda. And even this provision for redundancy is part of that decent work agenda, that you can't just declare redundancy and ask everybody to go without paying anybody anything. So when it comes to redundancy, we have, yes, a law of maybe 1974, but it still meets best practice. And then, of course, what part of the question is, will employees, well, it says Section 91 of the Labour Act restricts application of the Act to clerical staff and manual laborers. How then do employers comply with international standards where none exist? It exists in our labor laws. So that has answered that question. But it says, will employees who are not bound by the Labor Act be left simply to the provisions of their contracts of employment? Yes, because the starting place, where you start from, is the contract of employment. So when there's an issue, for example, redundancy, we are talking redundancy now, you will go and look at the contract of employment. Is there any provision for redundancy? Is there a collective agreement? In most of the big in the industries, you will see in the collective agreements, there's always provision for redundancy. And this provision for redundancy payments has already been negotiated. And the fact of it being negotiated is a best practice. So where the employee is a managerial staff, administrative, in the professional cadre, his contract of employment will make that provision. And where it does not make that provision, the employer must negotiate. And where the employer refuses to negotiate, then a dispute has arisen. And then what happens? The employee comes to court and says, this is my problem. And then a good lawyer will now begin. In the pleadings, will begin to plead international conventions, best practices. All these are questions of facts. So it is not entirely correct that the national law has not taken care of redundancy. And where the employee is in the managerial or administrative or professional cadre, his contract of employment is the place to go and to look at, because the contract of employment binds both the employer and the employee. Thank you.
Keep the hands. Another round of applause for my Lord for that beautiful insight. I'll go straight to my Lord Honorable Justice Adewale. This question has a bit to do with occupational safety and health, especially from the perspective of the employer. And he says that employers seem to constantly get the short end of the stick these days in the application of international best practices and labor standards. During the peak of COVID-19, employees refused to take the vaccine and also refused to be subjected to constant testing. Yet employers are required by law to ensure a safe working environment for employees. The ILO advocates social dialogue as a solution to this, but employees have remained unyielding and unbending. With the termination of an employee on grounds of refusal to vaccinate or be subjected to frequent testing or contributing towards the safety of the workplace be adjudged as discriminatory? Can employers mandate vaccination in view of the liability that may arise from an unsafe workplace? What options are open to employers? Are employers going to be given a leeway? My Lord, I know this might be in a very difficult situation because it can be a live case before the court. But for the purpose of this gathering, this is extrajudicial, and it's not necessarily the opinion of the courts. The issue of, in that scenario, that case pattern, if you can hold the employer liable still for failing in his duty of ensuring safe working environment. Thank you, sir.
Thank you very much. This nature of cases are actually live. So I will deal to the extent of. Thank you.
Thank you. Just as the HIV cases are also live, but this one deals with the safety at work. A scenario where, for instance, an employer leaves naked wires on the wall where you can easily get either a visitor or a staff of the company gets electrocuted by mistake. The employer has failed. So one would expect the employers to take better care generally. And now this talks about health. The employers are duty bound to provide safe working environments for their workers. Now, refusal to vaccinate, it wasn't quite absolute. That was why the leeway or the room or the window for frequent testing was provided for. So it's either one or the other. Whichever one, the employers needed to or need to ensure that the environment is safe for work. Now, 100 employees in a building, 99 of them are vaccinated, or 95. The remaining 5 that are not vaccinated, the question is whether they pose a health hazard to the others. And I'll say yes, because at the time these regulations were made, COVID-19 was an epidemic and we needed to be protected. It was a worldwide thing. And so I would say international best practices needed to be applied, and they were applied. I would say it will not be discriminatory to terminate an employee on those grounds. It's either you agree to be vaccinated or you submit yourself for regular testing. However, this can only be determined on a case-by-case basis because no two cases are the same. There could be circumstances, there could be exceptions, there could be dangers posed to an employee that makes it impossible for him to be vaccinated, and perhaps there are options, alternatives. For instance, if that employee is so important to the organization, you could give an option for remote work, and that was what was done in the Western world. And even here at the crucial moments, people worked from home. Although it wasn't perceived as an alternative, it was still expected that everybody will be vaccinated. The other part asked whether an employer can mandate vaccination. And I would say again, yes, of course, that would depend on the industry. For example, in the health sector, the nurses and the healthcare workers, they are at the front line. It will be most unheard of for them to refuse vaccination or testing. They are the ones that come directly in contact with the infected persons. And when they now say that they do not want to be vaccinated, they pose a health hazard to the other people. So in the health sector, it definitely would. The employer can mandate vaccination. There are many other sectors that would fall within this category, especially those that work in enclosed environments. But of course, again, we need to look at what the government policy says. Sometimes, like during the most crucial moments during the COVID-19 pandemic, there were various policies as it relates to who to go to work, who not to go to work, and all that. So by the time you apply the government policy vis-a-vis the mandatory need for vaccination, you might be able to, find that it becomes compulsory. Some people will say, I'm not traveling, so I don't need to be vaccinated. Maybe because, if it is because I will not be allowed to travel, but everybody was home. Nobody was traveling in those crucial moments. So you wouldn't really want to attach it to travel. In some government organizations, I understand they were not allowed to, if you were not vaccinated, you were not allowed in. Yes, those are quite reasonable policies of government, and I will align myself with it and say that if a person is terminated because he poses a risk to the other persons in the same working environment, then the employer has done the right thing. Because if the employer does not terminate such a person, he has failed in his duty to provide a safe working environment for the staff.
Thank you. Thank you.
Thank you very much.
Thank you very much, my Lord. Thank you very much. And it's important, my Lord. No cases are the same. And everything will depend on the peculiar fact before the court. My Lord, we thank you very much for the great insight shared. And now I take it back to Dr. Otaro Essay. Again, well, I'll call it the practitioner's view point, sir. The practitioner's viewpoint.
Okay, that's okay.
The practitioner's viewpoint on this. And maybe it's saying that in the application of international best practices, one area readily stands out. I mean, earlier on, the CIPM president said that for HR practitioners now, the fear of the NICN is the beginning of wisdom. I think that's caution is often or more regularly, or the concern there, I think that's a better word. The concern is more of, if the company gets it wrong, the compensatory damages that may attend upon that could be as large or could be this, could be that. So that area stands out all the time. Compensatory damages that can come upon a successful outcome of a claim instituted before the court by the aggrieved former employee or worker, as the case may be.
Yes.
Doctor, I'd like to hear your thoughts on the power that the court now has in relation to that exercise that enables, relies on international best practices that allows the court to go push beyond what appears to be the settled frontier of common law, damages being limited to what he would have been entitled to and all of that. And then in response, let me also sound this as well, that are there any concerns around that area? Beyond your thoughts, I can almost predict your thoughts a bit. Are there any concerns around how that power is exercised?
Thank you. You see, the award of damages, like I mentioned it earlier, the case of Sahara Energy Resources Limited and Ijeoma. If you've gone through the judgment of the Court of Appeal, which is the last court in respect of labor matters, you discover that it has been stated time and time that the award of damages is on the discretion of the court. It all depends on the exercise of discretion by the court. And there is another angle to it. And that angle is the circumstance of that case. Because, for instance, in that matter, they said the employee's image has been stigmatized. So you look at the stigmatization of the image of the employee. If his or her reputation have been affected as a result of that termination or dismissal, it has a lot to do with the quantum of damages. And so, and there are provisions, even in the NIC Act and the rest of them, as regards the power of the judex to award damages. Like I said, it all depends on the discretion of the court and the stigmatization of the employee. Like, for instance, you mentioned it earlier, moderator, that the focus is on the wrong of the employer. The wrong of the employer. Because most times, an employer will just dismiss or sack an employee without a fair hearing. For instance, in that matter, the lady was accused of fraud because of what they describe as the feedback for customers. And during the proceedings, in fact, they had to prepare a charge as if it was a court of law. She appeared before the committee. And a member of the management committee also participated in that during the plenary of that committee. And at the end of the day, it was discovered that all what they said was not true. She was not even giving query. She was not giving query, and the rest of them. So the point that we need to know is that one depends on the discretion of the court, depends on the circumstances of the case, having regard to the stigmatization of the employee. That will affect the quantum of damages that has to be granted. And the court granted a 2 years salary in respect of it, although we claim salaries and the rest of them, but I also claim general damages for breach of contract. And the court said, okay, yes, you have claimed that. Let me get out of the 10 million or 20 million for breach of contract. We give you 7 million, you give the employee 7 million. So that is the situation as regards the quantum of damages depending on the wrong. Like I said, I refer to the provision of section 13, which talks about law and equity. Section 14, which talks about remedies, which a court can grant. And of course, the section 19 of the National Industrial Court Act. So when you put all these provisions together, at the end of the day, you discover that the judge, has the discretion to grant. If assuming we were able giving 50 million, that would have been okay, in line with international best practices.
Thank you so much, sir. I think you address the concern, but I'd still like to take it back. Still on that concern, you address the concern, and rightly so. Sorry, sir. In referencing those sections of the Establishment Act, 13, 15, and 19. But again, I go back to the decision in Oaks Pension, which had been the currency before Sarah came on board. And there's this aspect, addressing that concern, there's this aspect, Justice Garba JCA had said that, yes,
the National Bank case.
Yes, no, the Oaks Pensions case.
Oaks Pension.
Yes, that I've been confronted. I've been told of Section 19, and I've read that I must still again interrogate this in the light of the contract of parties. Almost like thinking aloud that can the statute or should the statute now create a contract for parties?
Well, that's a very
of parties are said that in the event of this is what you'll be entitled to, almost still tied to the.
That's true. You see, there are also decisions of the Apex Court that parties can contract out of a statute. But with the promulgation of Section 254 of the 1999 Constitution as amended, I think, and it is a constitutional provision. And having regard to the provision of Section 1 of the Constitution, which I think, even though, because that contract for employment must have been generated from a particular law. So once it is inconsistent with Section 1 of the Constitution, I think, having regard to the fact that the Constitution is homegrown, what we lawyers refer to as auto channels, I think it will not fly because then we be resort to international best practices.
Thank you so much. Thank you, sir. Well said. A round of applause, please. Yes, I go back to the CIPN president. Sorry, if there are questions, and we'll come to questions now, shortly. We just have 2 more questions. I take it back to the CIPN president, and the question is like this. The question focuses on the knowledge gap. We're having conversations around international best practices today. And there's this concern that even in the world of work, the representative of management or the employer, that is the HR, more often than not, appears not to be up to date about what the law or what the position is in the world of work. That's so many things in the world of work. And thankfully, you made reference to that the CIPM is actively reading the decisions of the court. And of course, I'm sure you would have seen in many of the decisions, the court will take time to even highlight that in the course of the evidence led, in rebuttal by the employer, the HR person who came up couldn't say much. I remember one notable one on sexual harassment, the HR person who came up to speak for the employer in that case and was asked that you're on the 3rd floor. The person accused was on the 11th floor with the person who was making the allegation. And so how did you come by this information? You were not on the same floor with them when it was, and then they could just barely say that, well, that's what I was told. So the question is, it would appear that there's a knowledge gap with HR practitioners continue to apply outmoded employment principles in dealing with employees. For instance, despite the plethora of cases where the NICN had held that termination must be with reasons or that a dismissed employee must have been accorded fair hearing, and given an opportunity to defend himself or herself. These things are never done. Do you think it's a matter of knowledge gap? And if yes, what is the CIPM doing to bridge this gap? I mean, these are professionals that,
Okay. Thank you, Barrister Folabi Kuti, SAN. I mentioned it earlier, what we are doing as an institute. And I want to say thank you again, because in the last 18 months, I've worked very closely with you. You've even gone as far as introducing us to the president of the court, sincerely. And that's just a kind of the foundation for the collaboration we are looking at. The CIPM is neither for the employer or for the employee. The institute is for professional people, managers. And what we have done is that we can you imagine, since 1968, when the institute was birthed, and then we had an act of parliament giving us empowerment, not just to manage the practice of the profession, but to regulate. We have been reaching out to organizations, including organizations represented in this room. Earlier on, Tayo came up, and I want to give kudos to that law firm. I think it's Akin Oyebola or Oyebola. You're on your own. For having a qualified professional at the helm of affairs. And this is what we have been doing via the advocacy route. That, you see, the problem is that some of these HR practitioners have refused to be certified. What does the certification platform give to you? Constant education and re-education. Constant on learning and relearning. That is what we do in CIPM. That is the platform we provide for our members. You have been, on our platform severally at all levels. We have at the national level, we have the branches in all subnationals, and of course, we have chapters. States like Lagos, Ogun, Rivers have chapters. Zona, HR practitioners coming together to learn some of these things, and severally, these judgments have become, resources for us to learn. Therefore, what the appeal we are making is that whoever wants to practice human resource management must be certified. We are not just looking for members. We have value propositions for our members, and this is one of them. And we have conferences. I'm using one stone to kill as many birds as possible. Yesterday, this trip to Abuja, yesterday was the Abuja branch conference, and you needed to see the caliber of the faculty. So these are the things we do, because, if you do not train them, you cannot blame them. But I can tell you that the CIPM is well equipped. Now, one more thing, that haven't done advocacy these years, we are moving on to the regulatory level. And any moment from now, you're going to be seeing us. I won't use the word picketing because that sounds so we are going to be working and collaborating with organizations. If you are not a certified HR professional, you cannot practice. By the way, HR profession is like medicine, it's like accountancy, it's like law, it's like architecture. If you find somebody who is not certified lawyer practicing, what do? You arrest him and you bring him before the court. So, but however, because we are people, management, we have, empathy and so on and so forth. We have done that over the years. Going forward, you begin to show your certificate before you can practice.
Fantastic.
Thank you very much.
So much, sir. I mean, a lot has been said. A round of applause. Now it's time for questions. Let me take you. And there's one online that I will read out. Let's hear you, sir. Thank you.
Thank you, my lords, the learned senior advocates, the organizers. My name is Nasiru Idris. I'm an in-house counsel in Premium Pension Limited. I have had discussion around the